All right, I think it's time to get started. So welcome everyone to our roundtable discussion about the final 94C regulations, what towns need to know about large-scale renewable energy siting. So while it's tailored towards a municipal perspective, it's also helpful for the developer community and other members of the public. And I should note that this webinar is being recorded. It'll be posted to our USIS's website at some point after, that is noted in the chat. For questions, we're going to have those during our discussion segment that'll come a little bit later. We'll post in the chat and being able to read them out loud. But for the first half hour or so, we're going to have some brief presentations about just getting everyone on the same page about the 94C siting regime, how municipalities can effectively participate in this process for new projects, and what do these municipal and developer consultations look like, and where do they fit into that project approval timeline. And the remaining time will be, for about an hour or so, be panel discussion featuring 3 of our experts affiliated who are guests of uses. So first, Dwight Kanyuck. He's a partner at the law firm Knauf. His experience representing developers, municipalities, and landowners in the siting process. We have Kathy Spencer, the principal environmental analyst at LaBella Associates. She has experience in the design and planning of renewable projects, working with municipalities and developers. And finally, John Brookins is a master electrician in environmental technology, also at LaBella Associates. He has experience with all aspects of on the ground solar installation, and particularly working with towns and utilities in areas such as compliance with emergency response, as well as electrical and fire codes. So with that, I'll first very briefly discuss, what 94C is and, where we are now. So Eva, if you could please put up my slides. Thanks. So if we go to the next slide. So, and Dwight's going to cover this in more detail in his presentation, but where 94C came from was part of an act last year, the Accelerated Renewable Energy Growth Community Benefit Act, which included a provision establishing Section 94C to overhaul New York State's process for siting large renewables projects, centrally administered by a new agency, ORIS, and sets a centralized and uniform permitting process and establishes set timeframes for different process stages. And I should note that our webinar back in November that Dwight and Kathy presented provides a very detailed overview of the 94C process. And we would definitely recommend looking back at that if you're interested in learning more about the ins and outs of the law and regulations. But if we go to the next slide. So where we're at now is that last year, regulations were back in September 2020 were promulgated, also discussed in that webinar that covered the procedures and studies across the permitting processes that developers need to comply with. There are uniform standards and permitting conditions. You have to address the potential adverse impacts from constructing and operating projects. And the where we are now is about a month ago, on March 3rd, the regulations were finalized. So the legal and regulatory landscape is set. And this was very similar to those draft regulations that Kathy and Dwight had discussed. So really the theme for tonight's conversation is, now that everything's in place, where do we go from here? And particularly, how do we get these projects approved that enable towns to have their voices heard and to facilitate cooperation and understanding early on, while still ensuring that developers are able to get their projects done. And that way, New York State is able to meet their ambitious renewable energy targets. And what our panelists and discussion will go through tonight is really, beyond the letter of the law, how do we get this done? What are the implications on the ground? And with that, I'll turn it over to Dwight for his presentation.
Thanks, Alex, and good evening, everyone. And thanks to USIS again for putting on this webinar and this whole webinar series. I think the toolkit is a really useful tool to municipalities, and I think developers too, as they try and get the perspective of their partners in these projects. I think I just call it the energy storage webinar that was done. I think it was last month or the month before. I thought was one of the best ones I had seen on that. So, thanks to USIS for doing that. A couple disclaimers. My presentation doesn't constitute legal advice, and the medals behind me in the background, I had nothing to do with earning any of those. So if we could go to my set of slides. Great. Okay, and next slide. So what I'd like to cover this evening, and a little bit in the beginning, is going to be some overlap of what we did in November, just in case folks hadn't seen that webinar, just kind of ground folks on what the 94C process is, a little overview of the regulations, what's coming down the road as far as projects, and then a focus on the actual 94C process and how municipalities participate in it, how they can influence it. What are some of the things to look for, if a developer decides to do a project in your town, what should you expect? What should you ask for? And, and that'll lead, I think, into a much more detailed discussion with Kathy, where she'll be looking at where I think a lot of municipalities are in the pre-application phase or early application phase at least. So we'll hit a few key takeaways and then lead into Kathy's discussion. Next slide, please. So as Alex said, the Accelerated Renewable Energy Growth and Community Benefit Act, it replaced what was called Article 10 of the Public Service Law for siting large renewable projects. It was intended to streamline the process from Article 10. Like Article 10, it's a state level approval. We'll get a little bit of distinction between local and 94C approvals in a moment. The Act also started a NYSERDA program for what they call build-ready sites. I think those are focused on pre-developed projects, pre-developed sites to help mitigate some of the agricultural impact and put brownfields and landfills and such to use for meeting renewable energy goals. There was also in addition to the Act, where there was an explicit requirement that there be a host community benefit for the projects. I think this was implied in the past, so it's helpful to municipalities that there's explicit authority for this. There's 3 categories of community benefits that the municipalities can obtain as part of being a site for the project. The first bullet is actually essentially mandatory, where there will be a 10-year electric discount on residential utility customer bills. In host communities, it's $500 per megawatt of capacity distributed among each residential customer. From my understanding of some of the numbers it runs, and obviously it depends on the size of the project in the community, it might amount to a $50 to $100 a year discount. And then the other potential host community benefits are, I guess, the traditional agreements between the applicants and host communities, or as projects as determined by ORES. And ORES is the new siting office. It's within the Department of State in the executive branch of government. Public Service Commission used to do does Article 10. It was a quasi-independent agency. And then the Act also provided for transmission improvement projects and planning in recognition that to have the level of renewable energy on the grid that is proposed in this Act as in the CLCPA, which set a 70% renewable energy goal for 2030, that it's necessary to have transmission grade upgrades in order to handle all that renewable energy. Next slide, please. So this is just a feel for what new projects coming down the pike. This generally does not represent what's already been filed in the 94C proceedings or the Article 10. These were awarded renewable energy credits back in 2020. So these are projects where it probably represented the last bit of financing necessary for the projects to go forward. So you can see geographically, there's quite a few in Western New York. And if you know where the NYPA transmission lines run, you can kind of sketch it out, you know, especially up in Orleans and Genesee counties there in Niagara County. You know, there's a cluster of projects up there, and you know, towns where there is transmission infrastructures are particularly attractive for the projects. Next slide, please. So 94C process, how does it differ from, I'm going to focus only on, you know, what the process municipalities are familiar with, you know, your local land use processes. Many of you have likely had some community solar projects come through town, you know, in the 2 to 5 megawatt range, which are not within the 94C realm. 94C is for projects that are greater than 25 megawatts. They're required 25 or more. And a developer can opt into the 94C process for projects 20 or more megawatts. Now for a solar project, that's, you know, roughly 100 acres. And it might be a wind turbine project with maybe 6 or 7 turbines would be around 20 megawatts. So in the local zoning process, that would be the approval of generally your planning boards, some towns, the town boards. Whereas under 94C, it's a state level, one approval for all, essentially steps in the shoes of the towns, steps in the shoes of the other state agencies, and issues one permit covering all the permits that would otherwise be required. The exception being what are called federally delegated permits that the Department of Environmental Conservation approves. Those are essentially the equivalent of a federal permit, and 94C does not supersede federal law. But as far as state law, except for, and in the regs, there's carve out for certain approvals by the Department of Transportation and the Public Service Commission. All the approvals for the projects as far as siting are coming from ORAS. The application process, you know, municipalities, it's your site, it's your special use permit, it's your public hearings that you're used to. It's using seeker for environmental review. Under 94C, the new regulations have come out. Like Alex said, not a lot of changes really from the drafts. It largely follows, and we do environmental law, so probably not too many are too familiar with it, but largely follows the DEC process for major permitting with potential for adjudicatory hearings. So it's a typical, almost rulemaking type of process for the ORAS approvals. ORAS, the 94C process does supersede seeker. The environmental review that is part of the aspect of the 94C review was deemed to be equivalent, or at least it was explicitly superseded. I think there's some differences procedurally, but it was explicitly supersedes seeker. As far as public hearings, like I said, local zoning approvals, generally you have public statement hearings. 94C also has public statement hearings and comment periods. Adjudicatory hearings may also occur, but only, and we'll get into this a little more detail in a moment, if there are substantive and significant issues raised regarding the application. So under Article 10, there was always an adjudicatory hearing, and it covered almost all issues that weren't stipulated by agreement. So that's a big difference. That's a big difference from Article 10. And then finally, I think the other large distinction with the local approvals versus 94C is that for compliance with local laws, obviously, if you're getting the approval from the planning board, you're complying with the local zoning code. Variances are available. And in 94C, the local laws are considered by ORIS. There is a statement that the applicant is supposed to make whether the project complies with the local law. If it doesn't, the law allows that the local law, the 94C law allows local law to be overridden if it's deemed unreasonably burdensome on the applicant. As part of the 94C process, the towns also make a statement of compliance with local law. And then if the town wishes to essentially what I would call defend the law, it needs to demonstrate that the non-compliance is substantive and substantial, and the applicant then needs to make a demonstration that the law is unreasonably burdensome. So I think that's a key distinction. It's usurping the power of the municipality for approvals, but the local laws are given due consideration by ORIS, but there's a process to override them. Next slide, please. So this is and it's hard to see where the beginning and the end is on this, I admit. This is a flow chart of the 94C process. It doesn't have everything that could be in it, but it's from a municipal perspective, and the activities that are where the municipality has participation directly are in green on these. And I'm not going to step through this whole thing in detail, but maybe hit some of the high points. This is what the municipality should expect. This is how they participate. I think in working with your consultants and your legal team with the town, it's important to understand where you fit in, what the timing is. It's fast. There is a statutory requirement that the whole process from the point where the application is deemed complete to when there's a final decision is limited to 12 months. And I added up all the days that are explicit in the regulations for all of these, and that adds up to I added up to 284 days. So that leaves the only thing without an explicit time frame is the adjudicatory hearing. So that implies less than 90 days available for the adjudicatory hearing. So some of the key parts where the municipalities are participating, and probably one of the most important, and it's one most affected by the change from Article 10 to 94C, is what's called the pre-application phase, which is on the top in green. That phase was essentially more than a year and a half under Article 10. It's formally speaking, it's a little more than 60 days under 94C. The only requirement for pre-application is a meeting with municipalities, a meeting with the public more than 60 days in advance of the application going in. There's also consultation with certain local agencies. I have a list on the next page where they're supposed to be consulted to inform exhibits that go into the application. I think one of the keys is, though, that and this was in the comments to the regulation from ORES, is the developers are encouraged to do more than one meeting with the towns, and I think the developers recognize that it's important, and things go smoother if the more upfront planning you can do. I think in my experience, they have tried to do that, some to different degrees, I would say, but I think all at least to date have done more than the one meeting. And like I said, that's an important aspect to it. Following the arrow down, the application gets submitted in the ORES, then gets 60 days to determine whether it's complete, whether it meets all the requirements that are in the regulations for all the exhibits. There are a number of projects that are already in the queue for the 94C process under ORES. Those were projects that were already deemed complete under Article 10, and under the law, they were allowed to transfer into 94C without having to do the pre-application process because they were following the Article 10 process to do application complete, and they were allowed to skip to the application complete status under 94C. After that, 60 days later, ORAS will publish draft permit conditions. Essentially, the ORAS 94C process is a permitting scheme. And so ORAS will publish draft permit conditions based on the application, based on consultation with other state agencies. The municipalities aren't directly involved in the process in that phase of the review and the draft permit conditions. But after those are issued, that's when the municipalities weigh in on the draft permit conditions and application formally. Public comments, including municipal comments, can be provided. Public hearings are held. Party status petitions can be submitted. Disclosure can be had. And for the municipalities, the host ones, there's a formal statement of compliance with the local law. This is, I think, the key product in the early phase of the review. If the project is not compliant with the local law, the town will have to demonstrate that the issue is substantive and significant, such that a factual hearing is required. So I guess one of the questions is, and many towns have, is, well, how do you pay for all of this? How do you pay for, you obviously need technical consultants to review these applications if you don't have an in-house engineering staff, if your legal staff isn't familiar with the 94C siting. And this is a parallel track after the application is submitted. There is a request for funding that can be made. The applicants are supposed to provide $1,000 per megawatt into the fund. And those ORAS reviews applications for that funding. And there is a minimum carve out for local agencies at 75% for that funding to enable the municipalities to participate in the process, do the comments, do the review of the application, prepare a statement of local law compliance, and participate in the the downstream part of the process, the hearings and such, such that its voice can be heard, its influence can be had, and that if the project is going to happen, that it happens in a way that is consistent with what the community values are, and what and to a great extent possible, consistent with the local laws. So after those submissions by the municipalities, ORAS and the applicant can respond to those submissions. And then there's the administrative law judge does what's called an issues determination phase. That's where the judge will determine, are there issues raised by either the municipalities or community interveners? There is still funding available for community groups or individuals to participate in the process. There's up to 25% of the local agency funds are available for that. And then those organizations can also petition to raise issues, environmental safety, law compliance. The issues determination phase identifies what issues will be adjudicated, if any. Those are factual issues. Those wouldn't be legal. Those would not be issues that are solely legal. If there are no issues of fact that are deemed significant and substantive, such that it would materially impact the outcome of the permitting decision or the conditions in the permitting decision, an adjudicatory hearing wouldn't be held. That would bypass the whole adjudicatory hearing process and go to a final decision. If there is an issue identified that's substantive and substantial, it goes into what is essentially a mini trial. The hearing has disclosure demands, which is request for documents and such. Testimony is filed, including by the municipalities, especially if the municipalities are the ones that are raising the issues that are being heard. Essentially, they have a burden of proof, depending on the nature of the issues. If it's compliance with the local law, it's the burden of the applicant to demonstrate that the law is unreasonably burdensome. The hearing is held, and then after that 45 days pass, up to 45 days pass, there's a recommended decision. The parties, including the municipalities, get to comment on the recommended decision, and that recommended decision then goes to the ORA's executive director for a final decision on the process. So that whole process is a year. It's a year sounds like a long time, but there's a lot in there, and it gets it moves along quickly. And then finally, for those of interest, there is the ability to appeal the final decision of ORA's. It's what I would call an accelerated judicial review. It goes directly to the appellate division of the courts, and it's based solely on the record. There's no other hearings done. And next slide, please. Last slide. So just want to touch on a couple key issues. Kathy's going to get into this a bit in more detail. But like I said, ORA strongly encourages applicants to conduct additional community engagement beyond the single pre-application meeting. As a municipalities, you should ask for that. Ask for meetings, ask for information. It's part of engaging in the process. The projects come out better if that happens. There's a list there of these are the exhibits where there's some kind of consultation necessary with local agencies to prepare the exhibits. They may be planning officials, emergency response, information about where are sensitive noise receptors in the town, what are important visual viewpoints in the town, local historic preservation groups, highway superintendents are definitely part of it. And there's also supposed to be consultation on the costs to schools and municipalities associated with the projects. And I think something that John will get into perhaps, and Kathy, who's going to do the certification of compliance with the uniform code. And finally, as I said, the focus for the municipalities is on compliance with the local laws. It's important to make sure your local laws are current. I think a lot of the laws that were put in place only a couple of years ago weren't contemplating projects this size, especially I think the solar laws. And I think it's important to take another look at those, make sure that the community values are considered there and are incorporated into the laws. Those laws need to be defensible. I think as I've worked with other municipalities, as we've reviewed the solar laws, like I said, make sure you can communicate why you have a certain setback. Those will need to be defended if they exceed what's in the ORA's regulations, probably. And then finally, issues raised must be substantive and significant. They need to impact what the decision might be, or they need to impact the conditions that'll be in the permit. So those need to be framed in such a way that they can be adjudicated and defended. So with that, I'll go to Kathy for her session.
Thank you, Dwight. And hello, everyone. Eva, if you could start my slide deck, that would be great. In the meantime, my name's Kathy Spencer. I am the Principal Environmental Analyst at LaBella Associates. We're very happy to be with you here again tonight. And again, a thanks to the United Solar Energy supporters for inviting us. LaBella is a firm I hope many of you are familiar with. We have over 1,000 employees now, and we have a strong municipal practice, of which I'm a part, where we are advising municipalities. But I also want to put a shout out to our work that we do with solar developers, because we are, we have experts on all sides. We're a well-rounded renewable energy firm these days. And I'm hoping that some developer representatives are listening in, because what I'd like to focus on today is sort of a deeper dive into some of the things that Dwight was talking about, and what's really, like, let's get to the nitty gritty of what is happening for municipalities, especially in this early meeting with developers. I just want to mention again that John Brookins is here with me. He will be part of the panel discussion when we get through a few of these slides. And he also has on the ground experience with solar installation and planning. So I am looking forward to having him join the discussion. So next slide, please. Okay, so a lot of what we've heard so far about the law that was passed last April and the regulations which have been passed in draft and final form so far, you know, that's a lot about the state process that's going on now. It's a very legal process, as I'm sure you knew, as you listened in. There's a lot of legal terminology, and maybe some of that part of the process is unfamiliar to municipal representatives. So let's focus on, let's, like I said, do this deeper dive and focus on the two main points of involvement that a municipality will have. Most of my slides are going to be about this local agency consultation meeting that happens before the application has actually been filed, and then this municipal statement of compliance with local laws, which happens after the application has been filed. And there's about, by all the time periods that Dwight was going through, there's about 4 months between the latest that the local agency consultation meeting can be held and the time that the municipal statement of compliance will be due. Next slide, please. So early in the planning process, we're talking about this local agency meeting. What's supposed to happen is your solar developer or your renewable energy developer is required under 94C to hold a meeting with what the regulations deem as local agency, but what we can think of here between us as, a municipality, most likely a town, since these are projects that take a lot of room, but maybe a village or a city. So I wanted to start right off with looking at this list of who should be attending that local agency meeting. There's going to be a lot of information shared at the meeting, and the list that I've shown here is not necessarily all-inclusive. In other words, everyone on this list does not necessarily have to be at the meeting, but they are people you should consider having in attendance at the local agency meeting. Of course, the town supervisor or a mayor, if we're in a village or city setting, another member of the board or trustees. You may not want to have more than 2 board members present so that you're not subject to the meetings law, which would then make it a publicly accessible meeting. It's not necessarily a bad thing that it would be publicly accessible. That's another decision that the town or village should make among itself, was, do we want the public to be present at this meeting, or is it more of an information exchange directly between the developer and the town leaders? There is a requirement for a public meeting to follow this local agency meeting. So the question of public involvement is up to each town individually. Code enforcement officer would be a key participant. You may want to consider your planning board chairman or your zoning board chairman. We have the highway superintendent for both the town or the county. Might be someone you want to think about having attend. And of course, the emergency first responder people on the local level and the county could provide a lot of insight and feedback during the course of this meeting. Again, if all goes as it should, there can be multiple meetings where you have the meeting between the developer and the town leaders, and then later on the developer goes and meets with the fire and emergency response people. Not, to be biased, but I put in red at the bottom of this list, have your municipal consultant team at the ready for this meeting. This is something like Dwight and we work for different towns, or whoever you hire. You want that team present at the meeting. Usually the consultants are coming with a lot of insight, and we'll keep things on track and make sure the right information is exchanged, and can interpret it for you if there's something that becomes technical. So it's key to have your consultant team there to hear what goes on at this meeting. Next slide, please. So I have been involved with a number of 94C and Article 10 projects, and as they have sort of come to the fore over the last 6 months, I've watched this local agency consultation meeting take different forms. With COVID, it's been difficult to have anything in person. So I really sat down and our team at LaBella thought about, what is the vision for this meeting, and how does it work best? How can we help guide municipalities and developers to have the kind of information exchange that should go on? So this slide is the vision that we have come up with at LaBella for what really should be happening, kind of a roll up your sleeves, sit down and let's have some real dialogue between the municipal leaders and the developers. And that can only help both sides really of the discussion. So meaningful dialogue is my first bullet point. Another big thing that should be happening at this meeting is, let's get a shared understanding on the table of what the existing conditions are, what the project conditions may be. Let's make sure we all understand, the mapping and what's being shown. Of course, the third bullet point, there has to be a discussion of the compliance with local laws. That can also be followed by discussion of the technical issues and the information that the developer has ready to share. And then there's some administrative information sharing, website, contact information, that kind of thing. And finally, really a commitment. In the best case, the best scenario is there's a commitment to continue this information sharing and to be quite transparent and keep this dialogue going between the town and the developer. And I have sat in on a meeting that was run according to this vision, and it was really quite helpful. And I think both sides went away feeling good about the information exchanged, and looking forward to continued cooperation. And by the way, the meeting was held over a 6-hour time frame. That's how long it took us to get through everything that needed to be shared. I'm ready for the next slide. So I just wanted to quickly go through, I already started talking about some of this stuff. Just backing up to the meaningful dialogue, what's important to know about that is under 94C, the solar developer is already required to go have early consultation with state agencies. They're talking about wetlands with DEC, and they're talking about historic and archaeological resources with SHPO. They are required to do a whole endangered species review. So already before this whole application is filed, the developer is out talking to all these state agencies. And what we like to think of it is, let's have that same kind of information and consultation going on with the town itself. Get the early feedback from the town, because once that application's filed, there's really not a chance for a town to give feedback on what's in the application, only on how it meets the local laws. So the meaningful dialogue is important, but it's really the only chance to have that information and feedback about the project at this time. So moving on to establishing that shared understanding. What's really important here is having full-scale maps, if we can all meet in person, spread out the maps. They should be at an appropriate scale, so everyone, the town leaders can look and recognize landmarks in their town or buildings, or that's, the Smith farm up here. So if it's possible to meet and look over the same map, that's great. Or if everybody can look at a map on a screen. One of the biggest things to have on that map, aside from the project itself, is who are the neighbors? Where are all the residences? Are they residences that are participating, have some agreement with the project, or which are the ones that are not participating, so may be affected in a greater way? Are these buildings homes, or are they commercial buildings, or are they churches or schools or town buildings? Any classification of what receptors, we call them, or buildings are around the site are really important to see right off the bat. Again, so that misunderstandings can be cleared up. Everybody can see where the developer is coming from and who they think is around their project site. Hopefully at the same time, we're looking at a map of the project layout itself based on the most available information at that time. A lot of times, what's important for municipalities to understand is the developer wants to share site plan and design information, but it really may not be finalized yet. So there has to be a base understanding that what they're showing may change, but it's what they know at the time. It's the most recent information. Next slide, please. This slide just has some bullet points about what's important when we get to the part of the meeting where we're discussing compliance with local laws. All laws should be discussed, anything that's applicable, not only to construction, but to operation and long-term maintenance or decommissioning. We need to make a distinction in the local laws between what is substantive and what is procedural. The 94C law that Dwight was talking about allows that override of local substantive, all procedural provisions are already superseded by ORAS, the 94C law, but some of the substantive provisions can also be overridden, as Dwight had explained. a lot of times our towns are in the process of substituting a revised law for an existing law. So possibly at the time of your local consultation meeting, your revised law isn't ready yet. And eventually you can share some information about what that proposed law may include, and the developer may be willing to have a discussion about how they could meet those provisions instead of the law that's in effect at the moment. As Dwight explained, during this meeting, it's required that the developer identify any provisions that they know they can't comply with under the current project design, and what efforts they've made to try to comply with them. So that's an important discussion to have during this local agency meeting. And I think you can see why I was sitting in this meeting for 6 hours, because there's just a lot of information to exchange. Ready for the next slide. So then we get to a point in the meeting where you want to talk about some of the technical issues or basically the potential impacts on different environmental resources. I'm not going to go through all of these right now in detail. It's something we can talk about during the roundtable discussion. You might expect that developers will share some draft plans during this part of the meeting, possibly a draft decommissioning plan or a draft emergency action plan. Then if the first responders are there, they can give some immediate feedback on those plans, or there's something that we can all take back and read and provide feedback over time. But the developer should have some information at this point about what their impacts are going to be on, say, streams and wetlands, because as we know, they're already consulting with DEC. Endangered species is another topic that can come up. They should have the visual impact initiated, the visual impact analysis, so they can have some initial information on what viewpoints they've selected to do simulations of what the solar will look like in the landscape. So I'll just leave that list there. We can come back and discuss any of that as needed during our roundtable. Next slide. And finally, in this meeting, there's some basic contact information and other information that needs to be exchanged or provided by the developer. Again, the date at which the application will be filed or anticipated to be filed should be discussed. The availability of local agency account funds, that's the money that you can use to hire your consultant team. That should be discussed in the process for requesting those funds. Just a designated contact person and a website to learn more about the project should be prepared and provided to the municipal leaders. And then hopefully in the best scenario, and most of the developers that I've worked with on the different projects I'm working on are more than willing to plan for continued consultations and information exchange. But hopefully that commitment is discussed at the end of the meeting, and we all go off and start reviewing and providing more information back and forth. Next slide. So that was a lot of information about what has to happen at the, or a vision of how that local agency meeting can occur. The next opportunity really for the municipality to provide formal feedback as part of the process. Informally, hopefully the meetings and information exchange is continuing, But formal feedback is that second point of involvement, where the municipality files a statement of the compliance of the project with its local laws. This is about 4 months or maybe a little longer after the application. No, it's about 4 months after the application is found complete. It may be 6 months after this initial meeting, depending how early the initial meeting was held. But 4 months after the application is complete and can be reviewed by municipal leaders and their consultant team. Final slide. So I just wanted to provide my contact information at LaBella. We have a lot, the list of our renewable energy services there. If anything jumps out that you may need help with. And I think I'm going to stop there so we can get into questions and answers, and I can pull John Brookins into the discussion and his insight into compliance with the fire code. I also just wanted to mention LaBella has an article in the Association of Towns this month, and I think just came out today. So check that out. Uses also has an article in there. So there, we're featured talking about renewable energy in this month's Association of Towns newsletter. And with that, I will stop and be ready to join the panel.
Thank you for your great presentations, Dwight and Kathy, and looking forward to having you and John in our panel discussion. Just before we start with that, I just wanted to let you all know that USIS is sort of a clearinghouse of information about big solar in New York. We have a municipal toolbox featuring great examples of how permitting gets done, some great examples from towns about that as well. And also in our chat, we have the link to a prior webinar that Kathy and Dwight had done about 94C. Also some instructions if you want a training certificate after this call. And if you have any questions, put them in the chat and we'll get to them as we can. Any that we don't get, we'll try to circle back after. And with that, just wanted to start with the question for Dwight. We got a few questions about what do towns need to demonstrate to be substantive and significant? We know that this is defined within the 94C regulations, but just wanted some more guidance about what this might entail for towns.
Sure. So, like I said, those terms are defined in the regulations. I'll read them. It's an issue is substantive if it raises sufficient doubt about the applicant's ability to meet the statutory or regulatory criteria applicable to the project. So what does that mean? That means it's substantive. There's about 25 exhibits or so in the application. That means, is there, has sufficient doubt been raised whether the project will comply with the requirement and the regulations? Let's say for the noise standard, there's a noise standard of, and correct me if I'm off a little here, Kathy, 45 dBAs for 8 hours. If the issue is substantive, if you can raise doubt as to whether the applicant will actually comply with that standard. And then you also have to demonstrate it's significant. So it's significant if it has a result in either denying the permit, whether a major modification to the project or a significant additional permit condition is required. So you need to demonstrate that there's a criteria that is not being met, and also that it's something where the permit might not be approved, or that additional conditions may be required in the permit to ensure that the issue, let's use noise, is mitigated such that compliance is attained by the project that's consistent with the criteria that are used. And the regulations, I think, largely spell out all the substantive criteria. Where the towns come in is, occasionally the towns will have a higher standard, perhaps noise, perhaps setbacks. And the towns need to demonstrate, one, that it's, the substantive part of it is probably pretty clear. It's the significance is, what would be the impact of not meeting that substantive issue, and is it sufficient where the conditions in the permit would change as a result. It's a nebulous term. I think it's probably largely at the discretion of the judge, and there's not a terrible amount of case law on it. There's some, but a lot of it's with the DEC.
Thanks, Dwight. And I think, be interesting to see as more projects come through the queue, what the development of that case law looks like and the evolution of that term. And the next question is for Kathy. So during the pre-development meeting, is there a minimum amount of information or items that the developer must present? So for example, would they need to provide, let's say, given findings about critical habitats if they have it at that point? And how would the municipality know if a developer might be perhaps withholding any information?
There is not specific requirements on exactly what has to be and how much information would have to be shared on something like critical habitats. That information will certainly be coming out in the application itself. And most of the feedback or management of that issue will be from DEC, not from the towns. They don't have much jurisdiction over critical habitats. So the towns will find out about it when the application is filed if they are not finding out those details right in the pre-application meeting. I would say that that information is important to understand, but it's probably not as important as some of the issues of primary concern to a municipality, like setbacks, noise, decommissioning, emergency procedures, what the layout is compared to the roads, what the use of the roads would be, more municipal focused issues than so. Short answer is yes, there are requirements for what needs to be shared, but not the magnitude itself.
Another question for you also is, how does the municipality participate meaningfully with the developer if the plan might only be draft and could change? If the plan changes a lot, would the municipality get another meeting? And also, let's say if there's more than one town or perhaps a public involved, what might that look like? And could something like that mean be recorded, dispersed, or would that have to reign only to the parties?
So multiple towns are often involved, especially in wind projects. And often the developer will try to get all the town leaders in a room, or it'll be dependent upon what the towns and the developers decide is best for the information sharing that has to occur. And as to your first question about the changing nature of the plans potentially, that's not such a bad thing early on in the process, especially if a municipality points out, hey, that's our top-notch historical resource. We all go to the cemetery and look out over the view, and we really value that, that point in our town, or we're all familiar with it, or this particular intersection, or so changes aren't necessarily bad, especially if they're being informed by feedback that municipalities are giving, or the state agencies, where if something's cited a little differently, wetlands or critical habitat can be avoided.
And I think it's good to hear that that's not necessarily the only bite at the apple, so to speak, that there are the opportunities ongoing.
Yeah,
And
I wouldn't say there's an obligation to have another meeting if there's a change, but depending on the nature of the change, it might be in the applicant's interest to run it by the towns again and get feedback. But
and on a little bit of a different tack, what agency would be responsible for building permits? And also maybe to bring in John a little bit, how do you make sure that the solar facility is in compliance with code, and particularly around, any fire safety regulations that might arise?
I guess maybe I'll take the threshold question, and John can weigh in on the detail of it. The building permits, that's a local permit, so that ultimately is under the ORIS umbrella. They're part of the application is identifying who would be responsible for overseeing code compliance. It may be an agreement with the town, it may be a third party that's contracted to do the code compliance work, issuance of building permits and such, perhaps keeping the towns in the loop, let's say, but that's part of the ORA's process. There would be a condition on, and you generally it's in by agreement, where the there's more often than not a third party that would be the certifying entity for the codes, with oversight from the towns.
I don't really have much to add to that. You're right on. It's all at the end done by third parties.
Yeah, thank you for adding that. And just to follow up with you, John, a little bit, what are, just from on the ground day to day, what do you see are some of the most important issues for, code compliance with these projects, and particularly around, fire safety? There's also been, as more solar projects are being built with storage, some potential safety issues there. What do you see on the ground as the big challenges going forward?
On the ground, we're not really having a whole lot of challenges. The challenges are usually met long before it gets to us in on the ground, with all the permitting and other steps. The hardest things to keep track of are not really to keep track of, but to put in perspective are, roadways for emergency vehicles. A lot of times they're not thought about. They're not thought about on the ground as much as they are when we're in the planning. And that, to me, is one of the most important things that we've got to start being more diligent on, is expanding the roadways, getting the right turnarounds, and making sure that we have all that access for the emergency vehicles. So then, especially with the new battery storage, there are going to have to be larger vehicles getting onto sites. And this is something that we haven't had to deal with in the past. So this is a big step moving forward, and something that I feel we should get towns and the fire and rescue departments involved with in the planning process.
Yeah, thank you for that. I think it's interesting, as you're saying, thinking about the emergency plans from the get-go and getting in, when Kathy was mentioning, the list of who should be at the table, think about also, fire safety and emergency response in that long list of important parties, because there are just so many different parts going on. And changing a little bit, so this one's for you, Dwight. You'd mentioned a bit before about the request for funding for technical consultation for municipalities. I believe you'd mentioned that there's a 75% that might have been earmarked towards them. Can you please clarify, a little bit more about this process? And also, do you see that these funds are being effectively dispersed, or are there potentially, any things that municipalities should know about that in advance?
Sure. So, like I said, there's a what's called a local agency fund. It used to be called the intervener fund under Article 10, and it's funds set aside by the developer. It's $1,000 per megawatt to fund consultants to assist the the municipalities or community groups to participate in the process, technical and legal support generally. There is a minimum 75% amount that is set aside for what's called local agencies, which would be municipalities, districts, commissions, counties, and such. So government agencies, essentially. Generally, the requester of those funds are the host municipalities, and they would bring in the other local groups, as well as the counties, I should say, too. The counties do participate directly, often teaming up with the towns. There can be up to 25% available to community groups. So let's say a nonprofit group that forms that may have certain issues or concerns about a project. Perhaps it's different focus than what the town might be focused on, and those can obtain up to 25% of the funds that are available. The municipalities can get more than 75. That's the floor, I think, for the municipalities when it comes to that. And the key and the criteria are there's a form on the ORA's website, but for the application, they consider certain things like, what is your available funding outside of the local agency funds? How will you use it? What consultants will you engage? What are their qualifications? So definitely the judges, certainly with Article 10, and I would expect no difference here, look closely at, who's going to be, what will the funds be used for? How will they inform the applications is really how it's framed. How will they allow the entity to participate in the proceeding, inform the record, and also there's encouraging partnerships with other participants in the proceeding. So, I think those are the keys to, I think, successful applications is making sure that those ideas are communicated, that your team has the right qualifications and are working on the right things. So, I think, given I think there's a heightened level of participation in these proceedings, I think, than even in Article 10 for the municipalities. Article 10 had a 50% floor. I thought the 75% floor was appropriate, given the new process.
Thank you for that. And it'll be interesting to see, particularly given the amount of hours that, let's say, might be needed by technical consultants and, rates that are charged, will that intervener, or sorry, the new funding, be sufficient for them, perhaps. And I think as it plays out, something important to see.
Yeah, I mean, the cost to participate can vary quite a bit depending on whether you go to an adjudicatory hearing or not. And you really don't know that for sure when you're signing up initially. So to some degree, you have to manage things.
And, another question is that, some of the main issues that have been seen in helping municipalities draft solar zoning laws have seemed to be setbacks, screening, maximum height, and lot coverage. Question is, do you know how flexible ORIS might be on those and other issues, given the language about ensuring that local laws aren't unreasonably burdensome on developers?
So, and so when the regulations came out, ORIS also had, they had comments on the comments to the regulations, and they actually had a rather long passage about setbacks, because the regulations have minimum setbacks, and some of them are pretty small, in my opinion. They didn't get changed from the draft, but the setback from the road of 50 feet from the center line always kind of stuck out to me, because a lot of that tends to be about a 17, in my estimation, is about a 17-foot setback from the edge of the road. Be it as may, there was, I think, a signal in the comments to the regulations that ORAs would be taking kind of a case-by-case look at the setback issue, depending on the circumstances in the municipality and the issues that are there, and what's in the local law. And this is where I think it gets into, if the towns are setting setbacks, and I know some towns have much higher setbacks than what's in the ORA's regs, it's important to communicate why. Why do you have, say, a 200-foot setback from the road? And there's good reasons why. But it's important, I think, to communicate that, put it in the resolutions when you pass the laws, that type of thing. I think there's a signal that ORA's, I think, is going to be a little flexible on those, but there's got to be a good reason why communicated, where, such that they would go, above what's in the ORA's standard. The ORA's ones, I think, are definitely meant to be a floor, especially I think the solar ones. I think the wind ones, and Kathy may have a better feel for these. I suspect they're not going to be as flexible on those. But I think like setbacks on solar and things like that, I think it'll be interesting to see as the case law develops on those, where it goes.
Yeah, so I think the early information we're seeing on wind projects is ORAS is not shy about overriding regulations, local regulations. There's only, last time I checked, which I think was last week, there were only 3 draft permits out. And ORAS, basically, without much explanation, overrode a lot of the local regulations where there was a conflict between what the developer wanted and what the municipality wanted. I think the key thing, the key message that I believe, and maybe Dwight can even elaborate on this, is if your laws do not mention a certain topic, a certain, like say, if you have no mention of setbacks in your solar law, which would be unusual, you have no vehicle or no avenue then to comment on that later when you're supposed to do your municipal statement of compliance with local laws. So you should make sure every topic that is important to the town is in your local law, so that if it is overridden, you still have the opportunity to put your point of view forward and say, this is why this is important to us. We really want, these certain setbacks or this noise limit. But if you say nothing, like for some of the wind projects, there's a, lighting issues, and should the lights be blinking, or should they be radar activated when a plane flies through? Well, if a town's wind law doesn't say anything about radar activated lighting, then it can't comment upon its desire for radar activated lighting because it's not in their wind law, which is the only vehicle they have to talk about compliance of the project with their local law. So even if you think your local law may be overridden, put in it what you wish to happen so that you can go through possibly an adjudication hearing and raise a substantive issue. At least you'll have that opportunity.
Yeah, and I think that's a good point that, for towns, if you want to have your issue heard, you got to raise it early. So that way it's part of the conversation, because you never know, as plans change, where it goes. And, this brings up sort of a framing question, is back on Dwight's chart and based on his calculations, it seems like this new 94C process is something that could happen, the approval project, in, let's say, 280 days or so. When you're looking at the previous projects that were going under Article 10, the old siting law, the early wind projects were taking multiple years to get approved. Even some of the relatively newer ones are, definitely over a year. So question, Dwight and Kathy, what are some of the main changes you see in making sure that municipalities don't necessarily get left behind in that? And then perhaps with the pre-development meeting, could you imagine that there's almost some sort of, let's say, structural template where perhaps it could be like a half day or full day meeting with the developer, where you have at least your agenda set, and then you can tailor as needed for the specific issues of the municipality.
Yeah, we have put together agendas for that, those meetings, and they have been well received by the developers we've worked with, because the developers, generally the ones that we've seen and worked with, seem to be committed to meeting the municipality in every way that, meeting its concerns and addressing them in every way that it can. So, like I said, the meeting that I went through, there was an agenda. We pretty much followed we talked about all those technical issues on the slide that I had toward the end of my presentation. It was a 6-hour meeting. I think to do it in any less than that is going to be tough. And it was also socially distant in person, and that was better than having it online.
Yeah, and it'll be interesting to see, particularly in a post-COVID era, what that looks like. But in the meantime,
Yeah.
where this is still, unfortunately, very much a thing, and how still with the goal of facilitating communication between developers and towns. And I guess now for the last about 10 minutes or so, we have a few technical questions. So the first is around roads, and that, will developers be required to study the capacity of roads to handle the weight of trucks delivering equipment before the meeting, the pre-development meeting, or the municipality, will they be expected to know that information? And also, if there's perhaps needs to be an expansion of, let's say, roads for emergency responses, John mentioned, who pays for that?
I don't think the road technical details are expected to be provided by the municipality at that early meeting.
They're required to be in the exhibit, but yeah, they're not
Yes,
expected by the town.
in the application itself, right. There will be, I've seen a lot of information exchanged on roads. Typically at the meeting, the project's at a point where they talk about which roads they're going to use, and maybe start talking about details of a road use agreement. But the town isn't expected to have those details at the ready. Hopefully it's ongoing communication. And the meeting that I attended, neither the highway supervisors or the fire emergency officials, neither of them were there. And because it was understood that they would have separate meetings on those particular detailed topics.
Yeah, there is an expectation in the regs that the developer consult with the highway superintendents and such to talk through all those issues. And the issue as to who pays for improvements that are necessary to, let's say, handle some of the trucks. That's the developer through a road use agreement type of arrangement, or worked into the community host agreement. There's certainly not an expectation that the town pay for those type of, or the counties pay for those type of improvements.
Thank you. And I think that, as we're going through these technical questions for everyone, one general thing is, a lot of these matters are set forth in those 94C regulations in terms of, the framework for them, but also a lot of the details do get hashed out between towns and developers, particularly, during the early stages of what that looks like for a prospective project. And so next area we've got around agricultural land. So can you talk to any agreement between NYSERDA and the Department of Agriculture and Markets about the collection of an agricultural land mitigation fee if a 94C project impacts active ag lands or high quality soils, Particularly, is there any provision of that fee to be spent locally or in the host county to implement a protection plan?
I am familiar with the ag mitigation fee that's mentioned in that comment, but I don't believe it's part of 94C. I have to tell you, I've been pretty busy, so I have not dissected 94C on every issue yet. I remember hearing about the ag mitigation fee. It was on community solar projects, as I recall, I think. And then I remember a discussion where I had with someone where we saw that fee not showing up in 94C. I don't think it's there under
Yeah.
94C.
Yeah, I think you're right, Ken. I think that's part of the might be part of either the rec contracts or the New York Sun contracts for the solar incentives. And there is a mitigation fee for endangered species, takings and such that are in the 94C regs. Those are discussed. It was actually part of the statute too. But there isn't a reference to the ag mitigation fees in the ORAS regs. So I guess I'd have to look at, how those contracts are structured with NYSERDA as to how those fees can be, how those can be used. I know that there's usually, and I'm going to community solar projects, is my experience with these, that the local ag districts will weigh in on the projects and require certain mitigation techniques and such, and that is part of the 94C ag mitigation strategy that's included in the exhibit to the application.
And next, on visual impacts, who determines how many points of reference must be included in the visual impact analysis?
Typically, the developer hires an environmental consultant on their end, and that environmental consultant puts together the visual impact analysis. The ones that we have seen, there's usually early communication with the towns asking for their input. There's usually one letter that comes out that says, what are the sensitive visual resources in your town, and would you identify any specific viewpoints? And that's usually followed by another letter that says, here's our early results of what we think may be the important viewpoints in your town. We've labeled them all, we've numbered them all. Here's the ones where we think we're going to simulate the view. Please give us your feedback on that. So I've worked with towns where they do give feedback, and typically it's a conversation back and forth. The town might suggest A, B, and C. The developer says, sure, I'll do A, but don't you think B is kind of close to this viewpoint I already have? Okay, I'll switch that viewpoint to make it more like B. And, so there's just a back and forth. Usually in a cooperative way between the town and the developer. There is I think the developer has the final say if somebody, really was going to put their foot down. ORAS could chime in, I guess, but, or maybe it's an issue that could be, subject to a hearing, but usually in the end, the developer will either cooperate or put their foot down and say, no, these are the ones we're doing.
Yeah, and I would say though that's an issue that's ripe for the town to include in there. I mean, usually the solar laws or especially because there's more you can do is for mitigation, have pretty good visual impact requirements in there, and so that can be framed as a compliance issue. So that the municipalities can raise those issues if they are dissatisfied with how they've been presented.
Yep, and I thank you for that. And I know we're coming up on time. So just with the last few minutes, as coming away from this program, I think municipalities thinking about how do they structure pre-development meetings. And Kathy, you had mentioned your agenda that for the meeting that you had attended. Would there be any way for you to be able to share that, or perhaps do you think are there any examples of the types of how a municipality might be able to structure such a meeting that you know of?
Yeah, I'll have to think about that. That's right now it's a work product for a specific project. So, and it's something that we kind of teamed, brainstormed together and came up with. And it was based off a very careful reading of the regulations and what's required in there, and then just a lot of common sense. And really, any town can follow the slides that we have put together, and bring to the fore the issues that are most important to them.
Yeah, I think the last slide that I had there had a kind of a bullet list of topics that are in the regulations, as part of exhibits where there's a required consultation. So there's really they're kind of required to have that consultation. So those topics are certainly appropriate for an agenda for that meeting. And in the regs themselves, there is on the community meetings there is a list of requirements there, although it's a little obtuse. But if you get into the exhibits, you can glean where the consultations are required. And that's what that bullet list represents.
And I would point you back again to that slide where I talked about the big picture goals. Your town will know the issues that are important to them, or look at Dwight's slides and my slides, but think through those big picture goals and make sure that that kind of information exchange and that the developer is bringing maps of appropriate scale, and that you expect to understand where the participating and non-participating residences are. That will help you form that agenda.
In another way, I mean, it's if you have your planning board has the criteria that they would use to review a smaller project. Let's say this is just a planning board on steroids, essentially. So if you were the planning board, what would you ask the developer for when reviewing the project? And that might be a good approach for doing it.
Thank you for that. And I think this is just, if anything, the start of when all these meetings are going to be taking place. And consultation, as we've said, it's important to have it early, important to have it ongoing, to really get all the parties involved. And I wanted to thank Kathy, Dwight, and John for their comments and presentations tonight. I think it's been really informative for everyone. And for uses to help inform you all, we'll have everything on our website, the recording, try to have the slides, us as a clearinghouse of information about, how to get big solar done in New York. And we will also, I know we didn't get to every question that was mentioned, so we'll try to circle back on some of those if you'd like answers with that. And also, one final thing I wanted to mention is, to get these projects done, needing the towns, needing the municipalities, but also thinking about the public. And one of the things that USIS has been doing is, one of the groups we've supported within USIS is Fuses, the Friends of USIS, which connects grassroots supporters of these solar projects and helping to organize, getting them the information they need, and that way they can spread and advocate for their communities. And we really hope to help people getting involved with the grassroots, and especially getting involved in these proceedings, making their voices heard for the big solar that they want in their communities that can help them. And with that, we look forward to keeping in touch with you all and hope you've enjoyed this.